look, what we're doing right now is the equivalent of having a sports car out in the driveway and learning to drive it by reading the instruction manual, which is useful, but it's probably be better if you could get in the car and take it for a spin. And so now that these cases have been initiated, we have somebody in the driver's seat who's just turned the key, and they're going to see how this thing works. And we will all see how this thing works. This thing being substantive and procedural rules of the Law of the Sea Convention and the dispute settlement process in that convention.
Welcome back to the Elements of Deep Sea Mining podcast. I'm Eric Young. Joining me for a repeat appearance, Coalter Lathrop. Coalter, thanks for being here.
Sure thing, Eric. Glad to be back. It's been about 10 months, I think, since we last met up here.
Yeah. So Coalter was on, I think, episode 21. Coalter is an international legal scholar, and I had you on last time to walk me through the announcements in 2025 about how the U.S. was gearing up to use its existing Deep Seabed Hard Minerals Resources Act, aka DSHMRA, to start kind of getting active and granting licenses or move towards granting licenses to actually exploit or recover resources from the seabed of the international area beyond national jurisdiction. So for people who are interested in the background and the context, I really recommend going back and listening to that episode. Coalter kind of gives a really good overview of DSHMRA and the ISA and how the U.S. has and has not interacted with UNCLOS in the past. But today we're going to talk about more recent developments, what's happened in that space since the last time we talked. I guess there's been a number of sort of big ticket announcements, and I'm really keen to have you here to explain them to me.
I'll do my best.
Maybe I should have started by asking you what you've been up to for the last 10 months, because it seems to me like you've been a little bit on the warpath of deep sea mining and fighting, I guess, this new application of DSHMRA. So give us an update on how you've spent your time in the last year.
Well, a lot of it I have spent on this issue, speaking and writing about it and submitting public comments on these applications. So, hard to say whether any headway is being made, and I'm, of course, not the only one in the fight. My position on this hasn't changed, and that is that I see this effort by the U.S. administration, but really by these corporate entities to enter deep seabed mining through a route that is not the ISA route, the International Seabed Authority route. I see that as a threat to rule of law, to our system of international ocean governance that's embodied by and large in the UN Convention on the Law of the Sea. I don't see it really being in the U.S. interest long term, but my concern is more with defending rule of law on the seabed, and specifically on the seabed, as you mentioned at the outset, in areas beyond national jurisdiction. So I've continued to do that where I see opportunities. I think part of that effort is an educational effort, just getting ideas out there about why this is a bad idea, and how, what are some of the avenues through which it might be fought and opposed. So we'll see. But I think, one thing that's definitely been confirmed over the course of the last 10 months or so since we spoke last is that this is an effort, not my effort, but the effort to revitalize and resurrect DSHMRA and the idea of U.S. unilateral authorization of activities in the international seabed. That effort has gotten a lot of momentum and a lot of hype. And I don't know where it will end. There are some who say, look, it remains commercially unviable. A new administration is going to come in and pull the rug out from under this whole thing. The ISA is going to do something that will thwart this effort. And I'm not necessarily convinced by any of those things. I'm hopeful that one or more of those will come to pass. But in the meantime, I'm doing what I can to put my thoughts into the administrative record with NOAA in anticipation of litigation there. And I'm trying to influence the decision makers in capitals around the world with respect to this issue. I'm not talking to any heads of state directly, but I'm writing and speaking and trying to get these ideas out there. So that's what I've been up to. We'll see. We might look back in 10 years and see that it had some impact. But
yeah, well, I guess, I mean, the idea there is this is all, I mean, for one thing, this is new and being developed. So everyone is figuring out how to interpret these things. And I think those of us who don't spend a lot of time thinking about how legal systems work like to think that law is fairly fixed and gets applied in a fairly impartial way. And so now we've got some legal questions that need to be sorted out, and that's going to happen over the next few years, but it will happen the way it's supposed to happen. And so I guess realistically, though all these things are going to be interpreted, and that interpretation is still a little bit open. And so the different voices and the different theories of the case that get out there now can have some real effect on how people react and respond to these open questions.
I think that's right. And hopefully I'm contributing to that a little bit. But again, we'll see. I mean, there's the law and there's political will. So,
and then there's public attention also. I mean, I think that a lot of things can happen by political will, and one of the big kind of countervailing forces to that is public attention. And really, how much does political will follow behind public attention? Ideally, it would follow behind what the public wants, at least in democracies. And so I think it's important, getting people, and I imagine also just politicians to up to speed on what's actually happening and why it's important, and what are the options for what can be done about it.
Yeah. And that's been my audience. I've been submitting these public comments in the NOAA process. But the real target audience for me is the decision makers in the 171 now states parties to the convention. When we last met, the number was 169. But Kyrgyzstan and Cambodia have since come on board. So 171 countries in the world are part of the international legal regime governing these resources. And they are the ones who I hope to influence with what I write and say, because they're the ones with the international obligations that they're largely not upholding at the moment. And they are also the ones with the standing to bring their treaty partners before the international courts and tribunals that might interpret some of these outstanding questions that you referred to. So really, they're the target audience that I've been going after for some time now.
So then let's get into some of the recent developments, your interpretation and reaction to them. Because so I was listening to our previous conversation, and a few things kind of jumped out at me that you cautioned that there's the potential for certain conflicts that could arise, one of which being we could have two different entities apply for licenses to the same area under two different licensing regimes. And this seems to have recently happened. So I wonder if you can give us details on that.
Right. So, I mean, that's one of the logistical hazards of having two unrelated regimes licensing rights in the same geographical area. And we have seen that happen already. We saw that with the first couple of applications. I mean, TMC USA's applications for Dishma exploration licenses overlapped substantially with TMC USA's sister subsidiaries, Nori and Toml, Nauru Ocean Resources Incorporated and Tonga Ocean Minerals Limited, with their areas granted under an ISA, International Seabed Authority exploration contract. So you already have geographic conflict, spatial conflict there. Now that one, TMC, the parent company, is trying to mitigate by having these inter-subsidiary agreements because they recognize the problem. And by the way, it's also a statutory barrier under Dishma, which we could talk about. But yes, now we have with these additional, 3 additional applications that have become public, we see that these new Dishma applicants are also predictably applying for areas that are already spoken for in one form or another. The 2 American metal subsidiaries are applying for areas that are reserved areas under the ISA system, which means they're set aside for the use of developing states. These haven't been let yet through any exploration contracts under the ISA, but they are part of the ISAs. They are spoken for. Let's just put it that way, under the ISA system. And now we have this, really interesting development where one of those American metal subsidiaries, I believe it's SeaX, has applied for areas for which Impossible Metals Bahrain has also applied. So, that's exactly the kind of direct spatial conflict that you would anticipate when everybody knows that the Clarion-Clipperton Zone of the Pacific Ocean holds all the goodies. And it's although it's a large space, it's a finite space. You're going to have these spatial conflicts. And so we're seeing those start to manifest.
Sorry, that's the one that jumped out to me as a real red flag, was that, Impossible Metals Bahrain, and if it was SeaX, are two. I mean, it was one thing when the metals company had applied for the same areas under two different jurisdictions, under two different kind of subsidiary companies, but we could imagine that the kind of reality of conflict there was going to be low. Although I feel like this is now causing some additional legal questions on the back end for them, where they have to kind of walk the line of saying, oh, there's no conflict here because it's one entity, or at least we have agreements with it between our entities. But then at the same time saying those entities that are applying under the ISA are not violating ISA terms by also applying under Dishma. And so we'll talk about that, I think, a little bit later, what's going on there. But the more problematic one to me seems to be this Impossible Metals Bahrain, which from, I think the comment I read, they had already applied for these areas, which are reserved for developing states like Bahrain to apply for. And then SeaX has applied for the same areas or overlapping areas under Dishma. And now you've got something that actually seems like the potential for a real conflict, whether it's a conflict just over the legal rights now or a future conflict when ships get out there and start trying to lift nodules from the same plot of land.
Yeah. And, Dishma anticipates the possibility of some sort of spatial overlap and prohibits NOAA from issuing licenses in areas that have existing licenses. Now, I would argue that that's not just other licenses issued under Dishma, but other rights to these areas under, in this case, the ISA's system, which of course didn't exist when Dishma was drafted.
Can you put a bit more color on that? Sorry, so Dishma, as we discussed last time, it really only grants any rights against other U.S. entities, and it doesn't give you any. I think you said you can't wave this piece of paper in front of anybody other than another U.S. company. But then there's something in the Dishma language about how you will also not be granted rights that conflict with other international obligations or something along those lines. Is that right?
Well, and that's another thing. So that's right. There's the broad sort of due regard issue, right? That a Dishma licensee can't, must exercise its rights with due regard to other ocean users. And that's just a basic rule of sort of conflict resolution when two entities are exercising their high seas freedoms that may interfere with each other. If that's the case, then they both are required to exercise due regard. And that's in Dishma. That's a recognition of a customary international law rule with respect to ocean use. I'm talking about a more specific prohibition on issuing a license to an area that is already spoken for. That's a much more specific and direct conflict between two potential rights holders. The legal question there would be, did Dishma intend to include rights granted by non-U.S. entities? The answer is yes, for sure, because at that time the reciprocating states regime was in place. So there were several other industrialized nations that created this regime with the United States and essentially said, we won't interfere with each other's license areas. As I said, the ISA didn't exist at the time. So one argument would be that they couldn't have meant the ISA, but my argument is that they don't specify in the statutory language who the issuing authority would have been or could be. and that we now have a situation where one issuing authority has given rights of one form or another to quite a lot of the Clarion-Clipperton Zone, and a new issuing authority, in this case, NOAA, by statute. Again, my argument would be that they would be prohibited from issuing rights to the same areas for the larger purpose of avoiding conflict. And the broader concept of due regard certainly plays in here. But this, again, is a very specific statutory provision. So one argument as to why Dishma, or NOAA rather, should not issue Dishma licenses in these particular circumstances is that it would violate the statute by doing so, because we have pre-existing rights. So we'll see. And what we have now, I mean, the Bahrain, the Impossible Metals Bahrain, which is a Bahraini subsidiary of a U.S. parent. So, we're starting to really get into the tangled web here. What we now have is very real corporate interests that are in direct conflict. So it's not just Bahrain has interests as vis-a-vis the United States, but Impossible Metals has interests vis-a-vis SeaX. And so, those sorts of pressures, that's what's new there as far as I'm concerned. The interests and the motivations among the corporate actors are in direct conflict. And so that's the part that's new. The idea that there's areas being applied for by an entity under one licensing system that's already spoken for under another licensing system, we've seen a little bit of that already, but here we actually have direct conflict between two corporations. So, and as you probably noticed, Impossible Metals Bahrain submitted a comment in the NOAA public comment period with respect to SeaX, saying to the administrator of NOAA, hey, we've already applied for these. Mm-hmm. So, DSHMRA has a very clear sort of priority of rights process. So who gets their application in first. But when you throw in a whole separate authorizing agency and system, how does NOAA's priority of rights apply there? I don't know the answer, but
I think it seems to me worth recognizing that a big part of the purpose of international law, and I mean just regulation in general, is just to manage the potential for conflict in areas. I mean, it's just so much better to have everybody work out who is going to have priority to certain things in, some offices with some spreadsheets and some maps, rather than have people kind of get out there and actually appear in conflict. I mean, not just to avoid the kind of kinetic conflict aspect, but it's just inefficient to have a bunch of people gearing up to try to do the same thing when they could be gearing up to do two separate things side by side that would just completely avoid the conflict without there being a problem. And so I think that this, to me, just kind of is a reminder of what the point of having an ISA was in the first place, is just to have a system that everyone can understand and can apply for, and to make it efficient. And then that raises the question to me, so the U.S. never fully signed on to the UNCLOS. DSHMRA was, depending on who you ask, kind of designed to just run in parallel until the U.S. did sign on. Is there some potential here that, we could end up with two regimes that play well together? Can the U.S. not sign on to UNCLOS, but say, you know what, we're going to make sure NOAA can be reasonable here, and say, you know what, we're going to continue to make our process interlock with the ISA process, and we'll work out who gets to grant licenses, in priority, and we'll just have two regimes that play well together. Is that an option?
I don't see it as a good option. Is it viable? I mean, how would the two prioritize between SeaX and Bahrain's Impossible Metals subsidiary?
I don't see what the people who think this is a viable path then are imagining is going to happen in the future. I mean, is this just actually a case where people aren't looking more than 3 years out? Or what do you theory of mind from the people who think that there can be a reasonable DSHMRA process?
I can't get into their minds. The cynical side of me says they pump their stocks and unload before they crash. I mean, there's a history of that in this industry with the players involved. And so, how much of it is just a cynical attempt at creating a fairy tale for gullible investors? I don't know the answer. And, how much of it is a bet that the U.S. imperialist attitude towards geography beyond our borders will only get stronger. I don't know. I mean, where they think, the reason this will work is because the United States is gonna stay behind it and is gonna be even more strongly behind it in the coming years, including with, I'm talking about naval escort, really, right? I mean, sort of the full-fledged resource grab that ultimately would require, in my view, warships at some point, right? Because there are, again, 171 other countries that are states parties to the other system, and they're big players. So I don't know. I don't know if anybody's gotten that far in their thinking. Optimistically, people are taking a Lockheed Martin approach, which is we're holding these licenses under Dishma that will be essentially grandfathered into the ISA system if the U.S. ever becomes a party to the convention. I think that in an ideal world, that's what would happen, but I don't see it as a realistic option. So I can't really speak to sort of the boardroom mentality around this. What I worry is that it really is the former. It's largely hey, let's spin a tail and get the stock price pumped up and make some money before the thing crashes.
My kind of assumption about the way people think is that people don't always think. I mean, for one thing, there's a lot of people involved. So different people are going to be thinking different things and having different motives. And another thing is that, people don't necessarily always have a full picture of what the plan is. It's often kind of one foot in front of the other, and we'll see where it goes, and following one another's lead. If the U.S. administration is saying this is a path, then the companies are focusing on that and not thinking about the big picture, long-term viability.
Yeah, and so part of what I'm trying to do is educate them as well. And I'm not pulling any punches. I'm not sitting here waiting to reveal my big litigation strategy. I'm trying to get out there in the world these very real risks. And in my case, what I've been pointing to for the most part is the international legal risks, that this just ultimately doesn't work for legal reasons. I mean, it might not work for environmental or commercial or political reasons, but it also doesn't work because there's a system of legal obligations that's in place, and it binds, 90% of the countries in the world. And to the extent that the U.S. And the U.S. entities that are applying for these permits need the cooperation of entities from those 90% of the other countries in the world, that's going to be a real problem for them.
Should we start with the new Dishma applications that have recently come to public attention?
Sure, we can do that. We have reports of more than 10 applications, these as many as a dozen sort of coming out through NOAA officials and in the press. We have 5 applications that are actually public and reviewable at this point. These are applications under the U.S. statute that you mentioned, the Deep Seabed Hard Mineral Resources Act, or DSHMRA. And the applications that are public are all for exploration licenses, in contrast to commercial recovery permits. There are indications from press releases by the metals company that they have filed applications for commercial recovery permits, and we see some breadcrumbs that seem to support those assertions, but we have not actually seen the applications themselves. So what we actually have, we the public, available to us for our assessment and our comment are the 5 applications that are public. Those are on NOAA's website and available through the Federal Register.
And who are the companies that are applying now? So I think anyone who follows deep sea mining was aware of the metals company before they applied to Dishma. There's also, we discussed last time, some existing kind of almost grandfathered in exploration permits, licenses from Lockheed Martin. I'm not sure if there's others that are still holding them. Those go back, I think, to the 80s. And then now there's these new companies that are applying for permits, and they really are kind of new companies. I don't think they were active in the deep sea mining space or maybe even existed as of a year ago.
Yeah, that's absolutely right. So there's 5 applications that are public and 4 companies have applied. So 2 of those applications are TMCs, and then there are 3 other applications from 3 other corporate entities that have established themselves in within the U.S. jurisdiction. 2 of them, the American Metal Resources Company and SeaX, are subsidiaries of the same parent company, which is American Metal Incorporated. Now, American Metal just came into being in January of 2025. So as the Trump administration, second Trump administration, was starting to appear on the scene, there was some anticipation there, obviously within industry, that prompted the incorporation of American Metal and then the creation of its 2 subsidiaries, American Metal Resources and SeaX, who are 2 of the other applicants whose applications are public. So those are, 2 from the metals company, 1 from American Metal Resources, 1 from SeaX, and then the most recent one is from American Deep Sea Minerals, which was incorporated even later, just in August of 2025, less than a year ago. That company has just applied that company's application has just become public, I should say. So those are the 4 companies that have applied for the 5 applications. And then there's rumors of others, not rumors, but press releases by other companies. There's American Ocean Minerals, which is a subsidiary of a U.S. subsidiary of a Canadian company, and Deep Sea Rare Minerals, which is a South Carolina-based company, which just recently rebranded as Eco Materials. So those last 2 companies have press releases indicating that they've submitted and received some forms of approval from NOAA, but we haven't seen those applications yet, so we can't say much about what's in them.
So, maybe you're the wrong person to ask this question, but what's going on here? Why is there suddenly so much activity by companies that, surely they don't actually have any deep sea mining experience or capacity. So is this just someone has kind of cottoned on to the theory that there's a new sort of land grab, that this is a way to secure rights to something that may be valuable in the future? And these are kind of investment companies that are, thinking, okay, we're going to put together applications, get granted rights to some of these areas, and those will become valuable in the future. And we, or more likely someone else, might figure out how to exploit those one way or the other. This is my best guess of how these facts sort of fit together.
I think it depends on the company. Some of these companies do have some of their own experience in treasure hunting, for example, other sort of marine technology. Others of them are really just, a finance bro who decided to slap together an application. And it's a relatively low cost process. I could submit a Dishma application. The ones that I've seen, there are a lot of cut and paste sort of, products here. Really, if you look at these applications, there's not much to them. So fairly low cost to submit an application. And if you secure a U.S. license, I think there's going to be some value to that, perhaps. That's the sort of less cynical view. It's pretty cynical, but it's less cynical than just saying, these folks are wanting to get themselves listed on NASDAQ and pump stock prices. So to what extent this is just a stock pumping exercise, I don't really know. I don't have any insight into what these companies are doing, but that you form an LLC in Delaware and you submit a 120-page thing that AI could have done for you, and that's your application. There's varying quality among the applications, but at least one of them is just sort of doesn't appear that much effort or information really went into it.
Yeah, and I think that's a good kind of segue to the next thing I wanted to get into with you. Is another thing you kind of presaged the last time we spoke was where the teeth are in the IA in the enclosed framework, and what the actual legal route to stop a kind of illegal under UNCLOS operation. And the thing that you raised was, well, it's one thing if an American company manages to apply under DSHMRA operate entirely under DSHMRA. It's another thing when they need to use the services of non-American entities in one way or another. And so I'm also keen to get kind of an update from you on how that part of the picture has developed. I think you kind of mentioned that in the kind of chain of command here goes from UNCLOS to some of the signatory nations, and those nations really ought to put some laws on their books saying that they're going to implement what the United Nations Convention on the Law of the Sea says is illegal, that they have to kind of domesticate those aspects. And so have any countries done that? What's happening there? And I guess also it's worth it for you to kind of give listeners who haven't listened to that previous podcast kind of the full picture of what the issue there is.
Sure. 171 countries have signed and ratified or acceded to and thereby become party to and bound by the UN Convention on the Law of the Sea and its rules, which are rules that grant rights, innocent passage through the territorial sea, transit passage through straits, a big topic these days, rights to apply for exploration contracts through the ISA. But that convention also contains rules that impose obligations and duties on those 171 countries. And one of those obligations is an obligation to ensure that the conduct of a whole series of actors with respect to activities in the area, but activities in the area, activities related to deep seabed mining in areas beyond national jurisdiction, shall only be undertaken in conformity with the convention. And clearly, activities in the area undertaken pursuant to U.S. unilateral authorization are not in conformity with the convention, right? So that's where we start. That's the obligation of 171 states parties, including all industrialized nations in the world, really, except for the United States. So all of the countries that possess technology, ships, processing facilities, all of these things that are going to be required for this undertaking. So that's the international legal obligation. It's an obligation to ensure that this series of actors doesn't participate in activities in the area except in conformity with the convention. So we have in there, one big question is what is and is not included in activities in the area? What does carrying out activities in the area entail? I know you had a guest on who would want to really limit what carrying out means to maybe just the person operating the lift of the nodules, but I would say it's much broader than that. What are activities in the area? Are they just actual actions, physical actions, or are they broader than that? The definition of activities in the area is all activities for exploration. So that sounds pretty broad to me. It's been somewhat limited by the Seabed Disputes Chamber in their 2011 advisory opinion, and they've excluded the act of actually transporting nodules from the mining site to a processing location. And of course, they've also excluded the actual processing on land from the definition of activities in the area, but that leaves potentially quite a lot of activities.
Sorry, you said exploration, so this means that we don't actually have to wait until somebody gets around to trying to recover nodules, that this is going to
That's exactly right. This obligation pertains as well to exploration. Yeah, quite expressive. That's not a question. That's in the definition in Article 1 of this 300 plus article convention. There's a definition of activities in the area. It doesn't help us to answer all the questions about what are activities in the area, but they include activities related to exploration, all activities, in fact. So, and then there's the question: what's carrying out? Is carrying out financing the activities in the area? Is it ensuring activities in the area? Is it just operating the cranes in the area? That's an untested, an unanswered question. But whatever that answer may be, these 171 states have an obligation to ensure that this set of actors doesn't participate unless in conformity with the convention. So who are the actors? Well, states themselves have the obligation. Obviously, they are the parties to the treaty. And yet, this Article 139, which lays out this obligation, specifically says states also may not carry out activities in the area except in conformity with the convention. State enterprises, state-owned companies, their conduct has an obligation for their state to ensure. It also applies to natural and juridical persons, so individuals and corporate entities who have the nationality of a state party, one of those 171 states parties, or are effectively controlled, if not nationals of those states, they may be effectively controlled, and it's what that means. So we have the states themselves, state enterprises, individuals and corporations with the nationality of those 171 states, or individuals and corporations who are effectively controlled by those 171 states. And there's another category of actor that states are responsible for here, or whose conduct states are responsible for here. And that is natural and juridical persons effectively controlled by nationals of those 171 states parties. So when you think about the number of corporate entities and individuals that those 171 states parties have an obligation in respect of, it's huge. It's huge. And a lot of them appear, a lot of these corporate entities, I'm not even talking about the individuals involved, but a lot of these corporate entities appear in these 5 applications that we've seen so far in the DSHMRA process, 5 applications for DSHMRA exploration licenses. They appear as the applicant itself, so a U.S. subsidiary of a Canadian company, if Canada is a state party to this convention, which it is, if the Canadian parent has the nationality of Canada or is effectively controlled by Canada, which in my view, these 2 Canadian parent companies so far satisfy those criteria, and if those parent companies effectively control their wholly owned subsidiaries that are based in the United States, which they do, then Canada has an obligation to ensure that those entities do not carry out activities in the area except in conformity with the conventions. Has Canada enacted a law to criminalize the carrying out of activities in the area by its nationals or those effectively controlled by its nationals? No. I would say it's approaching a situation, and it may already be in it, where it is therefore breaching its international obligation. And it's an international obligation that Canada, in this example, owes to, at a minimum, the other 170 states parties in this convention. But it's been described as an erga omnes obligation, and so it may be that Canada owes it to everybody in the international community. But at least it's a treaty obligation that it owes to its 170 treaty partners plus the EU. And if it breaches that obligation, then it exposes itself to litigation, and that's where the teeth come in. Any of those other treaty partners could invoke dispute settlement procedures against Canada for breaching its obligation to insure under Article 139. Now, we can talk about whether this is likely to happen as a matter of international relations and politics, but as a matter of law, Canada, in this example, has an obligation to insure. We can talk about what that obligation entails on the ground, or might entail on the ground. And because it has done nothing that I've seen to carry out that obligation, it's approaching a point where it is in breach. And at that stage, could be brought before the Seabed Disputes Chamber of the International Tribunal for the Law of the Sea in Hamburg. And that's the point I've been trying to really drive home, because I think it's a very real, it's the only thing missing is a claimant state, is one of those 171 states, and 40 of them are calling for a moratorium, ironically, including Canada. And it seems to me there's enough interest in preventing this unilateral approach that the United States is undertaking that somebody is going to come up for air and say, yeah, they'll raise their hand and say, yeah, we'd like to go after Canada and Switzerland and the Netherlands and Malta and Cook Islands and Australia and Nauru and Tonga and the UK and New Zealand and Bahamas, right? And Belgium. And all 17 of those states whose nationals, corporate nationals, appear in the DSHMRA applications as either already under contract with the DSHMRA applicant, like ALLSEAS and TMC, or TMC USA, or they are the applicant themselves, like TMC USA, or they are named as potential partners of the Dishma applicant in their attempt to convince NOAA that they will have the technological capability upon issuance of the exploration license to carry out the exploration, which is a statutory requirement. But my count, just going through those 5 applications, there's at least 17 states parties to the convention whose nationals are either applying or in a contract with an applicant or named by an applicant as a partner in this undertaking. So I think that's a problem for those 17 countries. Now, what do they have to do? They have to ensure. We know a little bit about what that obligation to ensure means.
So, but have some of these countries enacted laws? Like you kind of laid out Canada's case, saying Canada has an obligation to domesticate some of these treaty obligations, and they haven't. Have some countries done that? And are any of those countries on your list of 17 that are kind of currently enmeshed in this?
They have, yeah. And, the UK is held out as an example of a country that has criminalized this participation and connected the proceeds of any unlawful activity vis-a-vis deep seabed mining to their money laundering laws. And I'm not an expert on that, but the UK is a state party that appears to have actually implemented its obligation and its domestic laws, and has quite a few nationals listed by these Dishma applicants as potential partners or members of a technical alliance that will be required, especially for these Dishma applicants who are really just shell companies. They have no assets, no mining assets of their own. So yeah, the UK probably already has immunized itself from the kind of claim that I'm talking about, because it actually has taken legislative, regulatory, administrative measures towards its obligation to ensure. But that's one of the rare examples.
So the UK has immunized itself, but now what is the risk is that some prosecutor in the UK could actually bring a suit against one of these subsidiary actors, and so this is where, I mean, now the risk has actually transferred from being a problem for the UK in international court to now being a problem for one of these companies in a UK court, and that's actually sort of a much more realistic and I don't know, it seems to me a more meaningful threat.
Yeah, they'd be charged with a crime under British law.
One of the things that I often think and often say about deep sea mining is it's a microcosm for so many of the other dynamics and dilemmas that the world is going through. We've got a case of, an environmental threat that is being driven by geopolitics and climate change and all these things. And it's an interesting kind of case study in how we look at a bunch of the other things that we're going through. And I think this is another instance of that, where even when one country has now tried to sort of say they'll go it alone, and the US says, okay, if the ISA is too slow to make the exploitation regulations, then we'll just make a US statute and we can just do this within our own, not within our own borders, but within our own legal regime. And then you realize kind of immediately that actually countries can't go things alone anymore, because we're all so interconnected. We're so reliant on people in other countries. And this is, again, it just kind of emphasizes to me the reason that we have international cooperation, international law, the need for coordination, because we're no longer, what's the word that everyone's throwing around these days? Autarkic. We're no longer able to just do things on our own.
Right. And here we have a pretty robust system in the law of the sea. I mean, if you think about climate change, we if you don't meet your targets, it's hard to see how a fellow treaty partner is going to go after you in a court. Here in the law of the sea context, it's quite easy to see how that happens, because the law of the sea contains within it compulsory dispute settlement provisions that, if you're a party to the law of the sea, you've consented to. So there's all kinds of international obligations that countries have with respect to human rights and the environment that they don't meet. But how are they held accountable? They can be held accountable in their domestic by their domestic constituencies. They could, sort of be named and shamed, but they can't be sued on the international plane very easily. That's different here. Here, if the Netherlands or Switzerland, and they both sort of claim some nationality over or effective control of ALLSEAS, which is a corporation that is now in a contract with TMC USA to be the operator in TMC USA's US authorized activities in the area.
Really, ALLSEAS is kind of everyone's only hope of actually getting nodules off the sea bottom at the moment. They're the only company that has demonstrated the ability to do it. So
Well,
they're really kind of
they're
clutch.
a linchpin company. Are they Dutch? Are they Swiss? I don't know. Are they a national of a state party to the convention? Apparently, yes. Is that state party fulfilling its obligation to ensure that ALLSEAS does not carry out activities in the area except in conformity with the convention? No, not yet. They haven't yet. Now, in both of those countries, Switzerland and the Netherlands, members of parliament are raising this issue and have been for a year now. But they've been re-raising these issues recently because TMC just announced its, formal agreement with ALLSEAS to make ALLSEAS the operator for TMC's activities under U.S. authorization. So, there's a little bit of a question of timing. Has the Netherlands breached its obligation to ensure because it hasn't done anything yet? And that sort of issue of timing is brought in response to these questions of parliamentarians in both of those cases, Switzerland and the Netherlands. The response from the Minister of Foreign Affairs or from the Swiss Maritime Authority is nothing's happened yet. Well, your obligation to ensure has already started. You already have the obligation to begin the process of taking action at the domestic level to ensure that these actors who are covered don't participate. But they haven't taken any as far as I can tell. And so there's already this, I'm just looking at it as the record, the historical record, which we'll look back on in 5 years when we're before the Seabed Disputes Chamber and say, did the Netherlands fulfill its obligation to ensure? Well, it was warned then and then again. And then when this happened, and then that happened, did it exercise due diligence? And so far, the answer would be no. What I hope happens is that, and what I'm writing and speaking about, is to alert the policymakers in these countries that they have this obligation. And that if they don't fulfill it, they expose themselves to litigation. I mean, it's really pretty straightforward, ultimately. Goosing that system, lighting that fire under legislators. I mean, I've watched the legislative process in the United States. I can imagine it's not easy to get these things passed, but maybe you need to be sued before Ottawa starts to legislate or before, folks in these other countries start to take action. And it's not just those three countries. I listed 17 that are sort of in the crosshairs here.
Can I ask, what's your best case scenario outcome? What's your strategy that your tactics here is working towards? Is that if we get enough international recognition of the nature of this problem, that, this has a number of stumbling blocks that are just not going to be resolvable by the kind of current pathway of applying to Dishma and closing our eyes, that eventually, by way of other countries enacting laws and other companies like ALLSEAS kind of saying, well, hold on, this seems to be a problem for us, that eventually we'll end up with a more unified international legal regime that is workable?
I think we have an international legal regime that's workable right now. I'd like to see us get back to the point where we were in, say, 2012, when Lockheed Martin's CEO wrote to Senator Kerry saying, we have these Dishma licenses, but we can't use them because they don't provide any security of tenure. And there's an international legal regime in place that governs these resources. And so we're not interested in risking our money, our corporate reputation, et cetera, to go this unilateral American route. I mean, that's been the position of Lockheed Martin pretty much since those licenses were issued in the mid-'80s, but expressly so in the 2000 teens. I don't know if it's still their position today, but it's the correct position. Like, yeah, we have this statutory authorization under U.S. law, but it's not worth anything in reality. And I'd like the investors in these companies to appreciate that and withdraw their financial support. And then they go away. I mean, That's the best case scenario in my view. Now, then maybe Congress repeals DSHMRA, which it should do. And then the Senate maybe accedes to the convention, which it also should do, but probably won't. Almost certainly won't.
Why do you say that? Why will it almost certainly not accede to the convention?
Because we got to get a 2/3 majority of senators, and we can barely get 51 to vote on the same thing. So, the vibe right now, I don't know if you've noticed, is not real pro, multilateralism and international rules-based order. Maybe that'll change. Maybe it all snaps back into sort of an immediate post-World War II mentality, but I doubt it.
I mean, that's my concern. And I try always in this podcast to be impartial and balanced, and I can tell I'm not entirely impartial on this topic because I am concerned about how we're in need of international cooperation. We're just in need of cooperation in life, and this seems to be driving us away from that. And then I worry also that this is driving cooperation. I mean, up until now, the U.S. has played well with the ISA. The ISA has just, I assume, been kind of hoping the U.S. would get it together and join. I wonder also how this is looking from the ISA's side, if there's any indication of, and I guess this goes to this other news item where there are now the ISA is scrutinizing the Nori and Toml license renewals. There's been some, I think, lawsuits. Nori and Toml have perhaps sued the ISA on this account now. You have to give me the details. But I now worry that, you start arguing with someone, the U.S. goes their own way, and now the rest of the world is going to be less in favor of cooperating with the U.S. and getting the U.S. inside the tent. And I worry that this is pushing everybody farther apart from both sides. So, I don't know what the question there is. Yeah, tell us about what's happening with Nori and Toml, and make me feel better about the potential for future international cooperation.
So in terms of, Nori and Toml have brought separate contentious cases against the ISA, claiming that their due process rights have been violated by an inquiry that looks at whether or not contractors, ISA contractors, of which Nori and Toml are two, are compliant with their contractual obligations, which is sort of shorthand for violating their duties under the convention and the contract itself. What appears to have happened is that Nori and Toml, who are sister subsidiaries of a DSHMRA applicant, TMC USA, Nori and Toml hold exploration contracts under the ISA. TMC USA, it's their sister subsidiary, is applying for 2 exploration licenses and 1 or more commercial recovery permits under Dishma. If you consider these 3 corporate entities to be completely separate entities, as Nori and Toml would like us to think about them, Nori and Toml are saying, how are we being accused of violating our contract by virtue of something that some other corporate actor, who we don't even know these people, right, is doing over across the sea? And yet it's perfectly clear that they are all wholly owned subsidiaries of the same corporation. It doesn't take an inquiry to find that out. It's in all of the SEC filings that TMC makes every quarter. So, it's not news to anybody that TMC, the parent company based in Vancouver, Canada, is effectively controlling its wholly owned subsidiaries, first and foremost, and that those 3 subsidiaries are somehow pretty intimately connected. But have Nori and Toml actually violated any contractual terms or aspects of the convention? I mean, I don't know what that inquiry has found, but one thing that's very easy to find is that Nori and Toml are in IP sharing agreements with TMC USA for the purposes of TMC USA's applications before Dishma.
Yeah, and that's actually really clutch because
I mean,
TMC
that seems like potentially a problem if you're sharing all of your exploration information. I mean, so TMC has a problem, right? It either wants to keep its subsidiaries completely separate and not just from each other, but from the parent company. But at the same time, it owns all of this data and it's sharing it across these different subsidiaries. Now, that wouldn't be a problem if it was just all happening within one legal system, but that's where you get these, this is the multiverse, right?
And I just want to note that sharing that data is what has allowed TMC to accelerate their application and apply for exploitation.
Exactly.
Now, what Nori and what TMC did under Nori and Toml is what gives them the ability to say, okay, we've already done exploration. And and this ties into that TMC was, by their lights, ready to do the next stage. They've done exploration. They're the farthest ahead of anybody, and can empathize that they're frustrated that they have been playing by the rules and have gotten to the lead position on the game board, and then the rule makers say, well, we don't actually have the rules in place for the next step, so you just have to wait until everybody else catches up to you. I 100% understand and think that there's legitimate kind of frustration there. But yeah, just to get that back to that, there's the connection between Nori, Toml, and TMC USA's Dishma permits is really strong and crucial because they're sharing this information.
They're sharing that information, and that may be their downfall, Nori and Toml's downfall. Who knows? If you flip it around and look at it from the perspective that I was giving you earlier, TMC USA is a Dishma applicant, which is relying very heavily on the nationals of two states parties to the convention, namely Nauru and Tonga. So are Nauru and Tonga in breach of their obligation to ensure vis-a-vis their nationals? Probably. Depends on how broad activities in the area is and what carrying out means. But this was carrying out of exploration activities in the area by nationals of Nauru and Tonga. So you have an interesting situation, and this is somewhat unique to the ISA dispute settlement regime, but Nori and Toml, corporate entities, are the ones suing the ISA, an international governmental organization or intergovernmental organization. So typically in public international law, countries sue countries. Corporations and individuals have to get their country of nationality to sue another country for some sort of breach. Here, Nori and Toml, the corporate actors, are not suing any countries, which in and of itself might be, that could happen. But they're just going straight to this intergovernmental organization. And it reminds me of a course that I just taught in May before these cases were brought. And the course was on dispute settlement in the area. So it was part of a larger dispute settlement under the law of the sea, sort of multi-lecturer course. And I was tasked with teaching for an hour what the dispute settlement processes are for the area, and specifically the exploitation of the mineral resources of the seabed beyond national jurisdiction. And, I prefaced the whole lecture by saying, look, what we're doing right now is the equivalent of having a sports car out in the driveway and learning to drive it by reading the instruction manual, which, is useful, but it's probably be better if you could get in the car and take it for a spin. And so now that these cases have been initiated, we have, somebody in the driver's seat who's just turned the key, and they're going to see how this thing works. And we will all see how this thing works. This thing being substantive and procedural rules of the Law of the Sea Convention and the dispute settlement process in that convention. So that, to me, as a lawyer, is exciting because maybe these cases get kicked out on preliminary objections, as I indicated, but maybe they result in some sort of decision that illuminates further how we drive this thing. So yeah, that's my car metaphor.
Yeah, so we're getting going. What you're saying is we're starting to ramp up into the real kind of legal world on this stuff, this dispute settlement stuff. The world is going to start paying a bit more attention.
Well, the world may pay a little bit more attention, and the judicial branch of all of this might give us put a little bit more flesh on the bones of what these rights and duties entail. And that's, for me as a scholar, an interesting thing, and as a litigator, a really important thing as well. So
great. Okay, I don't actually understand what they're suing about. There's they are suing just in
They're
case
saying
their
the
licenses.
inquiry. They're saying the inquiry is unfair. It's not transparent. It's violating their contractual rights. I haven't read their contracts. I haven't read any of the letters that are attached as appendices because they're not available. I can't really speak to it, but I think what's going to happen here. I think what should happen is that the ISA should file preliminary objections to admissibility and jurisdiction, and then the Seabed Disputes Chamber should kick this case out, both of them. So we'll see what happens here. I think this story just illustrates how tangled and difficult things get when you have two parallel systems. So at a minimum, it illustrates that. Where will it go? What's happening in Kingston in the legal counsel's office? I have no idea. But I do hope that they're being aggressive in their defense. And I do think that these cases are at a minimum premature. I mean, there's been no final decision. So Nori and Toml are trying to insert themselves in an ongoing inquiry that hasn't even resulted in a final
That was
decision.
the confusing part to me is they're objecting to the inquiry, not to the conclusion or to the finding, because the finding isn't there yet.
Right. Well, they're anticipating a negative finding, and so they're trying to get out in front of that. But I think they probably have to wait for the decision itself. And the inquiry doesn't name Nori and Toml. Nori and Toml named themselves, right? So this idea of unfairness or some sort of prejudice to their damage to their business reputation or whatever it is. No, as far as I know, Nori and Toml were not named in the inquiry as corporations or contractors requiring special attention. They named themselves. So, and in terms of participation, apparently they've been asked to participate in the inquiry, but they've refused. So who knows? But I think there are pretty good grounds for the Seabed Disputes Chamber just to strike it on admissibility and jurisdiction.
So, in trying to keep all this in my mind, this is the one place where the ISA has, or UNCLOS has kind of direct teeth. So you've been talking about this obligation to insure, which is kind of like in order for the kind of rules of UNCLOS to stop someone from going through DSHMRA, it has to go via assigning a state signatory, and they've got to take some action. But in this case, the ISA can actually say, Nori, Toml, you guys are breaching these rules directly, and we can do something such as not renew your exploration permits, and you can forfeit your license areas. That's like the one place where there's like a direct tooth that can be enacted here. And I think this is also interesting, relevant to keep in mind, and also a little bit scary to me as someone who is very kumbaya and let's all hold hands, that once the ISA starts to get whatever defensive or in a conflict mindset against these other actors, that this is just going to make cooperation less and less likely in the future. I'm kind of, part of me is like, well, should we be trying to turn as many cheeks as we can here to keep inviting the US into the process so that we have a good outcome, as opposed to get into a conflict that is going to result in breakdown of the international order.
Well, there's a lot of other contractors that are not in Nori and Toml's position because they are not tiptoeing along that line between the ISA and Dishma, or stumbling across it, or however you want to paint that picture. Impossible Metals Bahrain, a show for these guys, but they seem so far to be doing it the right way. In the right way in a number of different ways. Again, this is a Bahraini subsidiary of a U.S. incorporated seabed mining company. So they are applying for permission to mine within U.S. jurisdiction through the Bureau of Ocean Energy Management under a totally different process. I don't have a quarrel with that as a matter of sort of rule of law.
Mm-hmm.
U.S. exclusive areas of continental shelf with hard mineral resources that Impossible Metals wants to go exploit under a BOEM permit. Impossible Metals is also going into the ISA world through not the U.S. because they can't apply for an ISA contract as a U.S. citizen, but as a Bahraini subsidiary. Bahrain is a party to the convention, and they're going into the ISA process that way. Also, from a rule of law perspective, I've got no problem with that at all. And the U.S. can get into a relationship with Bahrain whereby the nodules that are raised by Bahrain's subsidiary end up on U.S. shores through trade. It's not as if the United States doesn't have access to these resources. It can friendshore these resources.
Yeah. I mean, as long as the ISA gets eventually exploitation regulations, and that I guess that's, I mean, we
Okay.
have to keep in view the driver of this is the extreme
Yeah.
rush that everybody's in.
Well, yeah, that's right. I mean, Impossible Metals Bahrain will not be exploiting under an ISA exploitation contract until the ISA issues it an exploitation contract. That's right. And that, as I understand, is a process that's ongoing. It's an international treaty-based process that 171 states in the EU are participating in. Where it ends up, I don't know, but as long as it goes through the process, I don't care. I mean, that's my basic stance on this.
There's a lot of talk now about how we need minerals quickly. And so this is,
Sure.
it's everybody who is worried about security of supply and critical mineral, et cetera.
Yeah, and so there's a lot of sources, and the seabed may be one, and Cook Islands exclusive economic zone is another, and the EEZ of the United States is another, and land-based sources in Canada and the United States are another. So I understand there's a sort of a demand or an anticipated demand, and so let's see how that demand starts to move the international regulation making process. But I understand that there's a very real human need for these particular metals, but this is largely being driven by individuals who stand to gain financially. That's my point there. And the narrative that if you can't do it, we're going to go somewhere else and take our ball, and the narrative that TMC's move to U.S. authorization means that the ISA has to complete its exploitation regulations in order to thwart unilateral activity authorized by the United States. That's not right. Anybody who thinks that if the ISA tomorrow completed its exploitation regulations and started issuing exploitation contracts, that would keep the Trump administration from pursuing these permits under Dishma hasn't been paying attention. That's going to have zero effect in Washington. So that narrative doesn't really fly. Why should the ISA wrap up its mine code? Because the states parties to the convention and the member states of the ISA are demanding it, not because the U.S. is demanding it. And of course, the U.S. isn't demanding. The U.S.-based subsidiaries of Canadian corporations are demanding it.
Yeah. I mean, I still, I feel like if I was in charge of the ISA, I would get on a plane and fly over to Washington and say, this is becoming a problem and it's in both of our interests to work this out. And here's an olive branch to get you guys on board with our system. And it's a good system. And we'll, work hard to make it work for you and your concerns.
Yeah, no, I hear your point on that. I mean, the USA has a way to do that. It's to join this convention that it crafted over the course of decades, and then had the world recraft to meet its demands. But that's not to say that this isn't a real threat to the ISA. I think it's a real threat to the ISA, and I think the ISA recognizes that. So
this is just another reason why I maybe it was the right thing that I dropped out of law school, because I'm just not adversarial in my nature.
You got to be adversarial. Well, I mean, cooperation is better, but in this particular circumstance, we have an incredibly adversarial setup where, one large actor is trying to impose its will on the rest of the world. And there are ways for the rest of the world to fight back in the legal system. Whether they take advantage of that opportunity or not is another story.
Okay, Coalter, we've made it, I think, through my list. I don't know if there's anything else aside from what you're doing upcoming. I understand you're heading to Kingston in July.
Yeah, I'm going to go down to the ISA. I've never been to the ISA before. I'm going to go down there to just take a peek, see what's going on, and to lead a roundtable discussion with some other international legal experts, basically just talking about that obligation to insure under 139. And we didn't even get into 137 and some of the downstream actors that might be implicated if they were to, exercise rights over any of these nodules lifted under a U.S. permit.
That's beyond what we've been talking about how subsidiaries have exposure. There's also some sort of additional exposure to the whatever chain of possession of the minerals. Is that what you're saying?
Yeah. I mean, we were really just under Article 139, the first sentence of paragraph 1 of that article, which really only has to do with carrying out activities in the area. And so we know from the Seabed Disputes Chamber 2011 advisory opinion that activities in the area does not include the barge that carries those nodules to Japan or the processing by PAMCO on the territory of Japan. So those aren't covered under the obligation to insure, but they might be covered under a different part of the convention, Article 137. And of course, Japan's a state party, as is Korea and Indonesia, the three places where it's been proposed that these nodules lifted by TMC or whoever else is ultimately successful in getting a commercial recovery permit from the United States. Hopefully there's nobody who's successful in that. But if there were to be somebody successful in that, the plan apparently is to ship those nodules to processing facilities in, at the moment at least, a state party to the convention. And do those states parties have responsibilities around their corporate actors, in this case, the processing facilities? If they do, they're not under 139, they're under 137.
Okay. Do you have details on your side event in Kingston that if listeners are going to Kingston?
Yeah, it's going to be held Monday, July 20th in the evening. That's the start of the second week of the council's meeting. And we're going to try to target the state delegations as opposed to the environmental NGO observers or the industry observers, because the message is really about the obligations of states parties around all of this. So I think we'll do an hour and a half sort of roundtable discussion, just hear what these various speakers think these things that you and I have just been talking about actually mean, and whether they have the teeth that I've just indicated. I think they have.
And you'll be there at Kingston talking to these people for the whole, or for a period. You'll get lots of additional insight. I mean, that's going to be, sounds to me, a very interesting time and place to be right now. You'll have the opportunity to find out who's thinking what and why.
Yeah, maybe. I'll be there for a few days. I'm not going to spend my whole summer there, but I'm really looking forward to seeing how it all works. And yeah, meeting some of the folks that are actually involved in policymaking back in their capitals. That's the target audience is folks who say, oh, either, we have an obligation to ensure that we're really not upholding. I need to go back and talk to our policymakers about starting to implement legislation and regulations around this to make sure that we aren't in breach of that obligation. Or, oh, we don't want to see this activity move forward. That is unilaterally authorized activity. And this is a way that we can try to keep that from happening, which is to say we could bring a case against one of our treaty partners and assert that they have breached their obligation to insure. So those are
well, then, anyone who's listening who's going to be in Kingston, find Coalter, and you can either be educated by him on all of this, or maybe even educate him on why his concerns are overblown and how this is all going to work out rosy in the end. And I'm sure even if you're not in Kingston, Coalter can be found on LinkedIn and a variety of places. And I think Coalter, you're interested in engaging on this. And I think that the more engagement you get, the more engagement we have on these questions, the better. So
I'm very interested in engaging on this, and a lot of what I've done over the last year is just reaching out to individuals involved in all parts of this and trying to establish a network so I understand what the lay of the land is and can hear different perspectives. And there's a lot of people working on this and a lot of people coming at it from different angles and with different motivations, and that's all well and good. I'm North Star is rule of law. I think this is a threat to the rule of law, and so I'm taking action.
Great. Okay, well, thanks for taking action. Thanks for including me in this podcast and your thinking. To listeners, we'll see you next week.
Thanks a lot, Aaron.